following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 30th, 2016 are currently trading with gold at $1,227.66 an ounce, silver $15.20 an ounce, Texas crude $38.28 a barrel, and Bitcoin is currently sitting at about 412 U.S. currency. Today in history, the year 1870, Texas becomes the last Confederate state readmitted to the Union. Though the new state constitution wasn't approved until 1876, Texas, formerly part of the Confederacy, was admitted into the Union. Today in history. In recent news, the Federal Trade Commission announced today its efforts to crack down on fake cancer charities. The Cancer Fund of America, Cancer Support Services, and their leader, James Reynolds, including Reynolds Sr., will have to surrender an undisclosed amount of their personal assets as part of a settlement with the FTC and states. These purported nonprofits agreed to be permanently dissolved and their assets liquidated. Reynolds is also prohibited for life from managing charitable assets or being part of a charity's board or a trustee. Apparently, according to the FTC, of more than the $75 million the charities raised, a vast majority of these funds were going to the charities' organizers and their friends, with a measly percentage, less than 5%, going to actual patients and research. To make matters worse, an estimated 85% of the millions were spent on fundraising for the scheme itself. The charity's remaining assets will first go to pay the state's litigation fees, afterward to actual legitimate charities the state select, though an FTC spokesman did state in an email that if there's any money left, it would probably be a very small amount. After more than 6 years in development, IBM's True North brain-inspired processor will be put to the test at the Lawrence Livermore National Lab. They purchased IBM's Neuromorphic System, a brain-inspired program based on the True North chip. California Research Lab is set to use it to help the National Nuclear Security Administration battle cybersecurity issues. Consuming just 2.5 watts of power, the same as a tablet computer, the neuromorphic system can process the equivalent of 16 million neurons and 4 billion synapses, containing only 16 of these True North chips. IBM chief scientist Dharmendra Modi stated that the delivery of this advanced computing platform represents a major milestone as we enter the next era of cognitive computing. This is Rick Rohde with your lowdown for March 30th, 2016.
It's 11:59 at Radio Free America, and this is Uncle Sam with music and the truth until dawn. Right now, I got a few words for some of our brothers and sisters in the occupied zone. The chair is against the walls. The chair is against the walls. John has a long mustache. John has a long mustache. It's 12 o'clock, Americans, another day closer to victory. And for all of you out there on or behind the lines, this is your song.
Good evening, ladies and gentlemen, and welcome. I have a joke for you.
Okay.
The government in this town is excellent and uses your tax dollars efficiently.
Thought you'd see it coming. The moment you
Bitcoin is immune from attack almost completely. With Bitcoin, you actually gain far more using that computing power to generate Bitcoin.
There's a system approaching perfection. It's in time for it to disappear. There's a system approaching perfection. It's in time for it to disappear.
We'll walk deeper into the belly of the beast. It means I'm able to further limit reckless government spending. I mean, I have so many ideas. Some are simple, like take down traffic lights and eliminate the post office. The bigger ones will be tougher, like bring all of this crumbling to the ground.
All right, well, good evening, ladies and gentlemen. This is the Crypto Show, a show dedicated to understanding the promise of currency, technology, and liberty in the pursuit of a free society. And if you believe, like we do, that such a society can and should exist, then join us, why don't you, as we parade through a world unbound by convention, a world sketched by the beauty of the human artist. Because each and every one of you listening right now is that artist. So for the next 2 hours, let go of your most sacred system of thought and entertain the possibility that maybe, just maybe, everything you've been told about currency, technology, and yes, even that dirty little word anarchy is only one part of an ever-expanding, ever-possible, complex universe of ideas, one that we simply refuse to explore. So what do you say, listeners? Let's do some universe exploring tonight and have some fun while we do it. Everything is awesome. All right, well, guys, tonight is Wednesday, March 30th, 2016. And, of course, we are coming to you live on Logos Radio Network. And, of course, I believe the fundraiser is still ongoing for Logos. So please go to logosradionetwork.com and donate. There are several prizes available through a raffle for first, second, and third place, and there's some sort of runner-up prizes. If you get in early enough, you get a free can of My Magic Mud. There's also some All About Vape gift certificates and some other really cool stuff. So check that out at logosradionetwork.com. And don't forget our sponsors, Brave New Books and Hill Country Home Improvements. And, of course, you can go to bravenewbookstore.com to the events page to find out what's going on this month or even next month, and order some of the products here on that page. If you can't come to the store in person, you have some of the convenience of that on the webpage. And there's the bitcoinbookstore.com also, where you can get over 50 titles on Bitcoin. Well, we do have a special guest tonight. And is Ladar, are you there? No, not quite yet. Well, our special guest is going to be Ladar Levison. He almost needs no introduction. He's been on the show so many times, and he's something of a tech celeb in his own right. Of course, for those who don't know, if you haven't heard him on the show before, he was the creator of LavaBit, which was an encrypted email service that happened to service Edward Snowden, of all people. But more importantly, it serviced thousands of people who benefited from the encryption of their emails through the LavaBit service until the government approached Ladar and said, we need the info of, so-and-so who's using your service. Can we have that? Well, that was sort of the excuse at first, but then it turned out the government wanted access to every single piece of data for every single email user on the LavaBit system. And in response to that, Ladar was like, you know what, that's wrong. And that totally flies in the face of, my own beliefs, not to mention the stated purpose of my company. So I'm going to shut it down. And he did. And as we like to say in the libertarian world, he went galt. And he's working on a couple new things that are sort of related to that. One, which we didn't get much time to talk about last time we had him on, is his new service, Darkmail, which is still in the works. It's basically a sequel to LavaBit, and I'm excited to talk to him at some point during the show about that because, every time we have him on, there seem to be new updates about that, and we get closer and closer to its launching, and I think there may be some other interesting revelations he has for us concerning things he may be working on. That was sort of implied to us last time we had him on. I won't say more than that. I mean, I don't know more than that, but I'm curious to find out if he's willing to tell us. So we'll also discuss that. But most importantly, and I think he may be on the line, so we'll get to him in just a moment.
No, he's on.
Yeah, I know.
Yeah, no, I'm on the phone. Can you guys hear me?
Right. Yeah. Well, that's just my radio lead-in. So anyway, that's Ladar Levison, and just as a quick background too, for those who are just listening to him as a guest for the first time, he was involved in the FBI case against Apple. And Ladar, welcome back to the show. And just to start off again, for those who need refreshing or don't know, give us the background of the case, and then we'll get into what you experienced at the hearing recently and what else is happening from here on out.
Thank you for having me back.
Always a pleasure.
I guess I'll start at the beginning. Many people will remember in early December, there was an Islamic couple out in San Bernardino County, Southern California, that decided to visit their workplace. They actually worked for the county and went on one of these all too frequent mass shootings. Now, what the Apple case centers on is a phone belonging to the husband, Ayad Farouk. He had multiple phones. He wiped his personal phone. He wiped his computer. But the phone that he had in his possession, which technically belonged to the county, was given to him as part of his employment, was not wiped, but was found powered off in the vehicle after the shootout with the FBI. Now, the problem was this particular iPhone, it was an iPhone 5C running iOS, I believe 8, was powered off at the time and was protected with a 4 to 6-digit PIN code. Now, starting with iOS version 8 and above, the way iPhones work is they combine your PIN code with a secret piece of internal information unique to that particular processor to form a strong encryption key, which is then used to protect all of the information on the internal storage disk. The FBI wanted to inspect this phone to recover mail messages, text messages, and other potential evidence because there's still this possibility rumored reports that there may have been a third shooter. They're also interested, of course, in learning if anybody may have supported him here in the United States, because they would like to ferret out that network and prevent more of these terrorist mass shooting style attacks. The problem was the FBI couldn't unlock the phone because if they entered the PIN code incorrectly more than 10 consecutive times, iOS was designed to basically self-destruct, or in this case, delete the AES key, instantly making the data stored on that phone inaccessible for all time. So what the FBI did is they went to the courts, the federal court, and they got a what's called a writ of assistance from the judge that required Apple to write a new version of the iOS operating system and then cryptographically sign it using Apple's encryption key so that updated version could be pushed to this particular phone. And what the order mandated was that this new version not wipe the phone after 10 consecutive incorrect tries, and that this new version would allow PIN code entries to be provided electronically via the Lightning cable. Apple, of course, took them to court. There were a number of briefs traded back and forth, 2 for the government, 2 for Apple. There were a number of external parties which filed what are called friend of the court briefs or amicus briefs. Lovavit was, of course, one of them. There were 17 total briefs in favor of Apple and 3 briefs in favor of the government. And one of the more controversial aspects of this particular case was that it was claimed its statutory authority under what's called the All Writs Act, which was passed approximately 220 years ago. And effectively grants the courts the ability to command or external parties to provide assistance with anything within, quote, their jurisdiction, which is obviously very broad. Now, on the eve of the hearing, which was scheduled for March 22nd, the FBI, along with the Department of Justice, announced that, quote, an outside party had approached them with a potential method for unlocking the phone without Apple's assistance. Now, everybody in the industry widely believed that it was possible to unlock this particular model and this particular revision of iOS without Apple's assistance. In fact, we kind of wondered why the FBI hadn't, for example, gone to the NSA or taken one of a number of hardware-level approaches that I can talk about later to get into the phone. So there is speculation that perhaps this sort of development was politically convenient, but DOJ, FBI went back to the court and asked to vacate the hearing, which is to cancel that March 22nd hearing, and stay the original order of assistance, which is basically put it in stasis, pending an April 5th status update. Now, what happened was Monday, the FBI, DOJ came back a week early and said that they had gotten into the phone and they wished to withdraw their request for the writ of assistance. And as of the last time I checked, the judge hadn't granted that particular motion, but it's widely expected that it will be, thereby ending the litigation without any kind of resolution.
And so, we're coming to break in about 45 seconds, but there's a lot of things I want to ask you probably on the other side about what you just said. But the attempt to end the litigation, then, does that leave open the possibility for the FBI to bring forth similar litigation in the future?
Yes. In fact, the ACLU released a survey today indicating that more than 60 orders have been issued by the courts to Google and Apple over the course of the last approximately 18 months, requesting their assistance to unlock phones.
I see. Well, we'll talk more about that with Ladar Levison, creator of Lovavit, and involved in this case on the other side. So stay tuned. We'll be right back, guys.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
This is what happens when you call the cops. Say what? This is what happens when you call the cops. Come on. This is what happens when you call the cops. You get your rights violated or you all get shot. This is what happens when you call the cops. This is what happens when you call the cops. This is what happens when you call the cops. You get your rights violated or you all get shot. I'm sick of people being victimized by criminal cops. Psychopathic predators terrorizing neighborhood blocks. Equipped with pepper spray, mace, cuffs, tasers, and glocks. They like serial killers acting out subliminal thoughts. Forget what you taught. These cops have got a license to kill. Witness intimidation means that they can use it at will. Go to silence means that the pigs will never let out a squeal. And if they go to court, they know.
All right, welcome back, guys. The lovely tunes of Rob Hustle. Go to robhustle.com to check out more of his work, including This Is What Happens When You Call the Cops. Always our intro on the second segment there. Well, it is, of course, again, Wednesday, March 30th, 2016, here on Logos Radio Network. Our sponsors, as always, are Brave New Books and Hill Country Home Improvements. And we're speaking with our returning guest, Ladar Levison, one of our favorites, smart guy, great at explaining stuff, and currently involved issuing an amicus brief for this case between the FBI and Apple. And as he was just explaining, basically in response to the San Bernardino shootings, the FBI wanted to get access to the Apple phone that belonged to the husband of the couple that were alleged to have committed the shootings. And they couldn't do it through sort of brute force because the phone would basically wipe everything. And so they were trying to force Apple to allow them to basically update the software to allow them to gain access. But now, as it turns out, they're withdrawing that. And part of that has to do with the fact that a third party approached them saying that they could do it for them. And apparently this is well understood that there are other ways to do this rather than forcing Apple in the industry. So it's clear that the very fact that they brought this case against Apple, probably with full knowledge that they didn't need to do it in order to break into the phone, is basically proof positive that this was a political move to change the legal climate with respect to these things. And that's a very scary thing because it's when they do that, it's not just about any particular case or any legal violations in any particular case. It's about setting precedent for the rest of us. And that is what makes this so scary. So, Ladar, I'm curious, who was this third party? Is it relevant? Does it affect our outlook on this case? And then, as I said before the break, and you seem to confirm, the FBI withdrawing seems to allow them to bring forth these legal cases again. And so, where do we go from there?
Well, let me start by saying that, in all fairness, the spokesperson for the Department of Justice said that this case was about getting into this particular phone, and once they had a way into the phone, there was no need to proceed with the litigation. So you really have to believe what you want in terms of whether or not you believe the spokesperson or you think it was just a political calculation. Now, like I said, it's widely speculated that there were various methods of getting into this phone before that they didn't fully investigate, despite the fact that an FBI agent filed an affidavit in the case claiming that they had investigated all possible methods already. A lot of back and forth there. But the bottom line is the case was halted before we reached a verdict. And there were a couple of important things about this case that made it somewhat unique. The first thing was that the case was unsealed because the owner of the phone, Sayat Farouk, was dead. There was also the fact there were several legal issues that were somewhat important to this particular case. There was the fact that because the phone was owned by San Bernardino County, there was no question of violating anyone's Fourth Amendment rights because the county gave permission to the FBI to search the phone. And then I had a third thing on my mind, and then there was the final element, which was this particular phone was associated with a particularly horrendous atrocity, which has a very emotional impact. Judges are supposed to be impartial, but they are human, and it's hard for them to say no when it involves something like a mass shooting and or terrorism. So the Department of Justice went into this case thinking that it had all the conditions in its favor. Unfortunately, they didn't fully sort of anticipate how vigorously Apple would fight back, how public Apple would make this, and what percentage of the public would come to their aid. Now, there was a poll done early on that found that more than half of Americans felt that Apple should assist the FBI in unlocking this phone. And what's particularly interesting is that as time went on and people became more educated about the issues at stake, that number dropped. And I haven't seen any recent polling data, but I wouldn't be surprised if Apple was now on the positive end of that stake. Either way, the lawyers for Apple absolutely destroyed the Department of Justice case, all of their legal arguments. So you have to think that maybe the shifting political winds, coupled with the disadvantageous position legally, might have had something to do with their decision to accept outside assistance. I've also heard rumors that several security researchers in the community had approached the FBI about providing assistance when this case became public, and that they were all rebuffed. So one has to wonder, who is this outside party that they finally decided to accept assistance from? Now, there's been wide speculation that it was an Israeli forensics firm, and a lot of that speculation has to do with the fact that there was a federal contract issued, basically a purchase order for approximately $15,000, right around the same time that this announcement was made. I'm hearing that was completely circumstantial. There is no confirmed source telling us who this outside party was. And knowing how lawyers speak, technically the NSA could be considered an outside party. It could be a foreign firm. It could be a private company. It could be an individual. We really have no idea. And the Israeli company that's been widely speculated, there are now reporters just in the last 24 hours who've been saying on Twitter that it is not this particular company. So I don't think we really know who provided the assistance. What we do know is that the method that was used for this phone was immediately classified. Now, that's quite significant. Because it's classified, it cannot be shared with Apple, nor does the FBI need to disclose it to the court. It's also significant in that if this method were to be used in another criminal case, the evidence gained from that particular device and any derivative evidence could not be used in that particular litigation because theoretically, the defendant could demand that the method for unlocking the phone be disclosed. I guess in theory, they could use the method in secret, and then you get into conspiracy theories about parallel reconstruction, which isn't exactly a theory, but how widely that actually happens is debatable. So that's kind of where we are today.
So, and just to clarify, the whoever this third party was, the method that they're using to break into the phone is classified. And so if they were to use the same method in a future case, they're not likely to do it because they would be forced to reveal that method?
They could potentially be forced to disclose the method if they used information from that phone in that case. Now, if we're talking about a foreign intelligence situation, a phone discovered on the battlefield, for example, it wasn't going to be used in a criminal prosecution, then certainly this particular method could be used.
That makes sense. Yeah, sort of a jurisdictional thing, like in the same way the CIA technically can't operate on the homeland, but it can, in a foreign lands. Well, we're coming to break.
Somebody should tell that to the CIA.
I agree with you there. I didn't say it actually happened. I said that technically, legally, in theory, that's how it's supposed to be. But that is definitely not conforming to reality. Well, we're coming to break with Ladar Levison, creator of LavaBit and Darkmail. And he was one of the, I believe he said, 20 or so parties that filed amicus briefs on behalf of Apple. And on the other side, among other things, I'm curious to find out who some of those parties were and who some of the three parties for the government were as well. And so we'll talk more with him about all this exciting, interesting stuff on the other side. So stay tuned to The Crypto Show. We'll be right back.
Honesty is the best policy, but for people who think otherwise, there's now software that helps you lie. I'm Dr. Catherine Albrecht, and I'll tell you about a disturbing new software trend in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Nowadays, faking it has become big business, with a whole industry built around helping people lie. Need to fake popularity? There are apps to create phony fans or make it look like your website is getting mad traffic. Or how about a girlfriend for your Twitter or Facebook account? You can simulate calls to your cell phone, spoof caller ID, and even fake text messages. But the worst has got to be the Alibi Network, a staff of professional liars who will tell any fib you want by email, fax, or phone. However, while these tricks may work for the short run, always remember, cheaters never prosper. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
What's your plan for tomorrow? Are you a leader or will you follow? Are you a fighter or will you cower? It's our time to take back the power. What's your plan for tomorrow? Are you a leader or will you follow? Are you a fighter or will you cower? It's our time to take back the power. What you gonna do when they show up in black suits on your street and I make boots and then silence you? What you gonna say?
All right, guys, welcome back to the Crypto Show. It is our third segment of our 2-hour show, and it's already been very informative with our guest, Ladar Levison, the creator of LavaBit and Darkmail, and one of the parties who submitted an amicus brief on behalf of Apple in this case between Apple and the FBI. And we'll find out here shortly what is the sort of aftermath of all this, if the case was technically sort of discontinued or dropped. Pardon me, that was sometimes we have to get a camera here in the studio. Thank you, sir. But just to recap what was kind of being said before I get to my next question, there was a third party that approached the FBI, as mentioned, and said that they could crack it without needing to force Apple basically to do so. And there was speculation that it was an Israeli company, but it looks like, by all accounts, it was a coincidental attribution because of a government contract that came up at around the same time. And to me, I mean, I'm not an expert, of course, and it's speculative. To me, it makes sense that it's not them, and for simply by virtue of the fact of the price tag. $15,000 does not sound like a lot for this kind of software work. I mean, I could be wrong, but I could tend to see why that is probably just a coincidence. Well, one thing that is interesting, though, about this case that I want Ladar to speak on is that much like his case with LavaBit, and we've already briefly touched on this both today and in his previous appearance on the show, there are related cases to this, and one of which is the EDNY case. So we'll have him elaborate on that shortly. But as a lead into that, I want to ask him, why do you think Apple began to resist the FBI in this matter? When did that start? And why is it that Apple was more cooperative in the past than during this case?
So, like I mentioned earlier, the ACLU has uncovered approximately 60 cases where Apple and Google have been asked to unlock phones over the last year to year and a half. Of course, it's still unclear how many of those orders ended up with a motion to compel. But what we do know is that beginning in approximately October of last year, Apple began refusing to provide this assistance. Now, it's important to note that before that point, Apple would provide assistance unlocking phones. However, with the introduction of iOS 8, a new encryption scheme was deployed, like the one that I described in the first segment, which made it impossible for Apple to unlock the device, at least without going through the methodology that we just described. So since October, Apple has disclosed through a separate case, a filing in a separate case, that there are 12 different cases spread out throughout the country where the government has sought their assistance unlocking an iPhone under the All Writs Act. Most of them are sealed, so we have very little detail about them. But one particular case that was unsealed because the iPhone belonged to a low-level drug dealer who had already signed a plea agreement was in the Eastern District of New York, and that was the case you just mentioned. Should we talk about that next?
Yeah, let's do so. And just out of curiosity, you mentioned that there were 12 related cases. Were these cases all roughly current and simultaneous, or like how far back do they go?
So the cases are dated sporadically starting in October, which is why I said that they began resisting these requests around that time.
Okay, I see. So all very recent and current. I see. Yeah, so let's get into more of this Eastern District of New York case.
All right. Well, what was similar about the Eastern District of New York case was that it was a request for a writ of assistance to unlock an iPhone. Now, in this particular case, it involved an iPhone 5S, which is a more advanced version of the iPhone, but the phone itself was running iOS 7, which did not employ this encryption scheme. In this particular case, Apple would not have needed to write new software in order to unlock the phone. It's also worth noting that with iOS 7, there are various experts in the industry that know how to unlock that phone. So technically, Apple's assistance wasn't even required to begin with. It's just that I guess the government had gotten used to going to that well. What was significant about that case is that a couple of weeks before the hearing was scheduled in the San Bernardino shooting case, the magistrate judge in that case came down and denied the government's request and delivered quite the scathing opinion, basically calling into question the government's legal authority, their methodology for deriving that authority, and said that even if those issues were set aside, there are serious constitutional questions that need to be answered. Very strong language, given the circumstances.
Well, great. Now, good job, Mr. Magistrate, for doing that. Yeah.
James Ornstein. Now, that case was immediately appealed by the Department of Justice to the district court judge. And that appeal was pending when this news broke about this new method. The parties in that particular case got together and agreed that the government would file a status update with the court by April 15th to indicate whether or not they wanted to proceed with that particular case. Like I said, in that case, it was very clear that Apple's assistance wouldn't be required. The government could have gone to a number of different vendors. In fact, the particular unlocking method, I believe, is actually demonstrated on YouTube if you really go searching for it. So it was a far more simple set of circumstances, but it tested this theory of whether or not companies can be compelled to provide this assistance under the All Writs Act. So we're sitting back and we're waiting to find out what's going to happen in that particular case. Like I said, the government needs to indicate by April 15th whether or not they want to proceed. And as of today, they haven't given any indication one way or the other.
And what do you personally expect them to do? Do you have any idea? Is it worth speculating?
It's really hard to say. The government, first of all, the San Bernardino case was also at the magistrate level. So, I mean, there's several levels that it would have had to proceed up in order for it to set any kind of binding precedent for the future. But the San Bernardino case, like I described earlier, had what I call a set of optics that made it a good test case. It was high profile. It involved terrorism. The owner of the phone had given permission to search it. There were a number of factors in play that were favorable to the government. The case in New York was quite the opposite. It was involving a drug dealer who had signed a plea agreement. So it was a far less emotional case, far less publicity. Like I said, it's widely speculated that if the government had tried harder, they could have found somebody else to provide assistance in the San Bernardino case. And it's quite clear, and has been all along, that there are alternatives to Apple in the New York case. So whether or not this new method is going to make a difference or not is yet to be determined. Now, one particularly significant development is because the government had to tell the court that they no longer wished to proceed and that they had gotten into the San Bernardino shooter phone, it's now clear and on the record that the FBI can break into these phones without Apple's assistance. And that certainly knocks one of the major pillars out from under them, because of the three requirements set up by the Supreme Court in the New York telephone case back in the 70s. In order to get one of these writs of assistance under the All Writs Act, the particular party needs to be unique and closely related to the case, approximately meaning that they need to be the only ones who can perform this particular service. The exact wording of it escapes me, but it'll be interesting to see what argument the government comes up with.
That's for
now
sure.
That they
we're
had
coming to
admit.
break. Sorry to interrupt, but Ladar Levison, we're coming to break.
Don't want a chip in my mother, a chip in my wife. I don't want a chip in my babies. Stay out of our lives. Don't want no shackles. Don't want no shackles on me. I sit down with Big Brother. Shame on that Big Brother trying to track and trace me and all you and tag the animals and tag everything on earth. I sat down with Big Brother. Down with Big Brother. Down with Big Brother. Shame on Big Brother. Shame on Big Brother. Always tracking and tracing me.
down with Big Brother. I couldn't agree more, Jimmy Vaughn. Jimmy, by the way, famed blues and rock guitarist and singer, brother of all other famed blues and rock guitarist and singer Stevie Ray Vaughan, is a fan of Brave New Books and has been here and has performed here as if the bookstore wasn't cool enough. In case you didn't know that, now you think it's even cooler. Well, speaking of cool, we're talking with King Ladar. That's his Twitter handle. Ladar Levison, founder of LavaBit and Darkmail, and one of the parties submitting an amicus brief on behalf of Apple. I did that last time. Apple in this case with the FBI. Well, Ladar, just to kind of clarify too, because this is a surprisingly kind of complex case as far as the details and the motives and all the sort of maneuvering that's gone on. And, at first sight, it seems a lot more cut and dry than might be the case. What is, you said compared to the EDNY case, the government had some favorable things going on with it in this case. You also mentioned, though, that at the magistrate level, it wasn't necessarily a precedent-setting case, even had they followed through and won. So just to clarify and wrap it all together, what was the FBI's, do you think, grand motivation in bringing this case to begin with, especially since they must have known, as you said, that they had alternatives to cracking into the phone other than, taking Apple to court?
Well, in the EDNY case, I believe the request for assistance was denied before it was ever issued. In the case of the San Bernardino shooting, they submitted their application for assistance, what's called ex parte, which loosely translates to without opposition. And of course, the magistrate judge went back and invited Apple to oppose it and supply briefs arguing against providing that assistance, which Apple clearly indicated they wanted to do. But the fact that the magistrate judge out in San Bernardino issued the order and was now debating whether or not to issue what's called an order to compel, which is the next step. First, you ask for the assistance, and if they don't provide it, you compel the assistance. And if they refuse to comply with the order to compel, then you hold them in contempt. Well, they were debating whether or not to compel Apple in the San Bernardino case. But because the judge issued the order and the request for a motion or order to compel was withdrawn, we need to mention this particular news source in talking about it. But at least one particular article on Ars Technica, to be specific, the author quoted portions of an email that was reportedly sent to him from another DOJ spokesperson. And while he didn't quote directly, he did say and characterize this particular email as saying the DOJ was claiming that the San Bernardino case set a precedent. It's kind of like a situation where you have two boxers step into the ring, they shake hands, the bell is about to be rung, and one of the parties decides to exit the ring and then runs around the arena claiming, I'm undefeated. That's kind of what we have out in San Bernardino. Now, what I think we're kind of getting towards is what was their thinking in going after the San Bernardino shooting case? And one thing you have to look at, if you go back over history, is that the government likes to pick, like I said earlier, these emotional cases, these high-profile cases with favorable circumstances, and litigate them to the end so that they get a favorable precedent that they can reuse in other less high-profile cases. It's the high-profile nature of the case that means lawyers across the country are aware of what's going on, and they know to look up this particular case whenever they, for example, come across these particular set of circumstances again.
That's a good way to define high profile. That makes sense. Yeah. So there is a precedent setting potential to this that would obviously be favorable to them. That makes sense, and it also makes sense too because
it really isn't. I mean, it's complete. If this is true that the DOJ is claiming a precedent, it's another one of these fallacies. Because, first of all, if a decision is issued by a magistrate judge, it's completely non-binding. If it goes up to the district court level, it is, again, non-binding. Any decision made at the magistrate or the district level can be ignored or followed at the discretion of another judge in any other case across the country. Now, of course, judges tend to look at similar cases for guidance when considering the same set of issues, but are certainly not required to follow the outcome of that other case. Now, what happens after the district court level is it goes up to the appellate court where it's heard by a 3-judge panel. That's what happened in the Lovovich case. And if those judges decide on the substantive questions involved in the case, then that particular opinion becomes binding in that particular circuit. Of course, the country's broken up into approximately a dozen different circuits. So again,
it would just be particular to that circuit and not all nationally. I see.
Exactly. So if a case was brought in a different circuit, it's quite possible that the judge could come to a different outcome. They're not required to follow that appellate court's decision. Again, judges tend to look at each other's work. So there is some influence across boundaries, but it's also quite possible and happens quite often where you have a circuit decision in one particular circuit and you've got a different decision in a different circuit. Now, one of the things that the Supreme Court likes to do is sit around and wait as new questions are raised in courts. They like to see them litigated several times before they necessarily grant a cert petition to hear the case, because when the Supreme Court decides to make a decision, it becomes binding across the entire country.
Didn't they already try to use Lovovich as precedents when it wasn't precedents?
So what happened in the Lovovich case is we went from the magistrate to the district court judge over the course of about 24 hours. So, just to give you some
quick,
scope, we're how many weeks, 5-6 weeks into the San Bernardino case, and we still don't have a decision from the magistrate, let alone appealed up to the next level. Basically, the government got an order to compel me in the Lovovich case the same day they delivered the Penn Register order. And then
they wanted it bad with
went from there to the district court judge to get a summons about a week later. And of course, the entire thing was litigated at the district court level within about 5 weeks. Now, in that particular case, the judge did issue the order to compel and then held me in contempt. Now, because I was a third party, I couldn't appeal the order to compel, but I could appeal the contempt charge, which relied upon the justifications in the order to compel in order to find me in contempt. Now, when I went up to the appellate court, kind of an open wound here, so you'll have to forgive me if I get a little emotional. But the appellate court saw the issues, didn't necessarily feel they were fully litigated at the lower level, but all of the relevant details were in the appellate briefs on both sides. And apparently they originally split 2-1 in favor of the government, but then went back and decided that this wasn't the right case to set a precedent and decided to use a contrived procedural technicality to avoid deciding on the substantive questions. Literally, if you read the opinion in my case, it's like 45 pages. They literally say they do not need to come to any conclusion on whether or not the original district court orders were valid, because I had waived my right to an appeal. What that means is there was no decision. There was a precedent set on waiver. There was not a precedent set on the particular question of whether or not the government could seize encryption keys in order to facilitate surveillance, or source code for that matter. Yet in the San Bernardino case, the government cited in a footnote that the Fourth Circuit Court of Appeals upheld a contempt charge. And they did it with text immediately preceding it that insinuated that particular appellate court decision decided that it was valid for a company to have to turn over its encryption keys and source code, when, in fact, the appellate court made no such decision.
Fascinating. Man, it gets so complex. That's what's so interesting. I see why people become lawyers, because it's like, it is almost like programming, I think, in a way. Well, we're coming back from the break in a couple of minutes with Lazar Levin.
Well, the FBI can't trust it. Just another spy can't trust
All right, guys, welcome back to the Crypto Show here on this lovely Wednesday, March 30th, 2016, here on Logos Radio Network. Brought to you as always by our sponsors, Brave New Books and Hill Country Home Improvements. And we're coming into the second hour of the show with Ladar Levison, creator of LavaBit and Darkmail, and one of the submitters of an amicus brief on behalf of Apple in the FBI case against Apple. So, Ladar, you were kind of talking about how, I guess I didn't quite even grasp this, or maybe I just forgot in your own case with LavaBit, they basically left it open-ended and didn't come to a decision. And they've done the same thing here with the FBI Apple case. And as you were kind of just saying off air, it makes sense because the case for the government was tenuous enough that they ran the risk of a bad decision not in their favor. And I will say, though, that even though we discussed how it wasn't necessarily precedent-setting in the case of Apple, it is a good PR move on the government's part because, one, by pursuing this with Apple, it makes them look like they're doing something to fight terror. And then, two, it keeps the whole terror scenario on people's minds. Maybe not in the general public, because probably not too many of the general public are following the case. But as you mentioned, lawyers and other legally conscious individuals and groups are following it. So,
well, certainly the engineering and, in particular, the information security community was following, along with lawyers. But there were also a number of political activists. In terms of cases, this was one of the most high-profile cases going on in the country right now, particularly given that it was at the magistrate level and it was generating the type of media coverage that you would typically get with like a Supreme Court case.
Right. You're right. That is pretty astounding because that's a very uncommon thing. Well, and so with your amicus brief, you submitted it with 20 other people, and we were talking about on air that they all kind of came in within the same 24-hour period. Do you think, and Danny was kind of asking this off air, someone asked it on air, do you think that you basically said one of the things working against the government was the tie to public opinion? As you also mentioned, there was certain surveys or whatever done that as people became more educated about the case, they tended to favor Apple over the government. Do you think the amicus briefs were influential in the FBI also not pursuing the case to its conclusion, in part because it reflected popular opinion and certainly reflected the opinion of these, probably very influential groups? And then what were some of these other groups that filed?
So there was a transcript published of a hearing that was held via telephone the day before the scheduled hearing, in which the government, the court, and the Apple lawyers got together to discuss this method and what should come of it. And in reading this transcript, the judge actually comments that she has read all of the amicus briefs and felt that, if I can try and quote, not all of them were necessarily written with the court as the audience in mind. I butchered that, obviously, but that was the general gist of what she said, basically implying that typically briefs are filed to influence the court, and she felt that some of them may have been filed more for political reasons than anything else. Now, the fact is, I don't think the amicus briefs necessarily swayed anybody, because I'm probably one of a dozen people, maybe 24 people in the country that read the briefs in the case that isn't either a reporter or a lawyer. These are not, a John Grisham novel. They are long. Some of them are written better than others. They tend to reiterate a lot of the same arguments, but they're talking about case law and legal reasoning. There's very little what I would call substance. But that's what you expect from a court of law. So, I think when I talk about public opinion, I mean the media. I mean the various activists and think tanks that are involved in these issues. I mean the engineering community. I mean social media. Because when this story first broke, it never mentioned encryption. It was simply Apple is refusing to help the FBI unlock the phone in the San Bernardino shooting. And Apple has done this in the past, helped the FBI unlock phones. And what the FBI is asking for is specific to this particular iPhone. They claim that they were not seeking something they could use with other phones, although that was quickly debunked.
So you're saying it was a choice? It was a choice, a mission of using the word encryption?
I'm saying the way the Department of Justice presented this case, combined with the letter that Tim Cook wrote the next day, painted a media picture that made what the FBI was asking for sound far more innocuous than it actually was.
Right. That's basically what I was getting at. Yeah, exactly. So the public and anyone else would be much more instantly and naturally on the government side with that little distortion.
Yes. And when those early polls were taken, that effect was still lingering. I mentioned this the last time I appeared on your show, but one of the interesting facts they found is that among independent voters, people who were not a member of either party, approximately 75% of the people polled favored Apple. So the people that tend to go a little deeper and question what they read in the media and not necessarily go along with the flow because that's what everybody else is doing, that percentage of the community had looked beyond the headlines, realized what was going on, and supported Apple in their fight. Whereas the sheep, as we like to call them, just followed the herd.
Yeah, well, that's not surprising. Yeah, that makes a lot of sense that independent voters tend to be more independent thinkers and certainly deeper thinkers. So naturally, they'd fall on the side of Apple statistically more than the government. That's at least good to know that there's still those people out there, Well, and I guess I want to ask another question too, and forgive me if it's redundant because maybe I didn't grasp it earlier, but I guess it's kind of dawning on me that one of the reasons the government has sort of not pursued cases like this to its conclusion, aside from maybe knowing the, what little was in their actual legal favor, or maybe aside from the fear of, being ruled against, is part of it the fact that the All Writs Act basically is a sort of carte blanche, not precedent, but legal tool that they can use so that they don't need to rely on certain future precedents in these cases. Do you know what I'm saying?
Well, I mean, the thing you need to understand about both the Lavovitch case and the Apple case is there weren't very many systems back in 2013 designed to encrypt the data in a way that protected it from the system operators. In fact, there were only two companies at that time that I knew of that offered that kind of service. Now there's several dozen Lavovitch clones. I like to think all of the clones are still about 10 years behind because, what I'm working on is still several years more advanced than, they're building copies of a system that I designed back in 2004, which based on what we know now, can't be relied upon as being secure. So I figure in about 5 more years, they'll realize that it's not secure and need to switch. And of course, by then I'll be working on my, quantum pocket phone.
They don't call him King Ladar for nothing. He's
right. I'm the king of all the Ladars.
Well, that's really impressive. I'm shocked that that only 2 or 3 years ago, 2013, there was maybe a couple companies, and you said protecting users' information from.
That was in the email space when we were talking about protected email. Now, if you compare that to the Apple case, it's only in 2015. I believe that was when Apple. I'm not an Apple user. I tend to dislike walled gardens. I like a lot of things about Apple. I love their hardware. I just don't necessarily.
Walled garden, I've heard that term before. Do you want to explain that?
Their products tend to be designed for the lowest common denominator. So as long as you do everything the Apple way, they're awesome. But if you like to deviate from the path every now and again, they make it very difficult. Now, what a walled garden effectively means is that everybody inside the garden plays nicely with each other, but it's the people who own the garden that control everything. And because of the walls surrounding the garden, it's hard to interact with the outside world. And in this case, what it means is with other products from other companies using open standards and open technologies.
Interesting. That makes sense.
So the iPhone is the epitome of the walled garden. You need to use iTunes to communicate with it. You have to get all of the software for it from the Apple App Store. It will only load apps that have been signed by Apple. They make the hardware, the operating system, and control the ecosystem that runs on it.
It's kind of fitting that Apple is the walled garden, right? Like the Genesis story.
Apple, it's kind of interesting because Apple is the walled garden, but yet they still have a very strong counterculture that derives directly from Steve Wozniak and Steve Jobs back in the 70s, being that whole hippie counterculture. So despite the fact that it's a walled garden where Apple likes to control every element of the user experience, the corporate culture is still very anti-authoritarian, which is part of the reason that they were probably the first company to step up and resist. Everybody remembers that iconic Super Bowl ad from the 1980s with the girl running past all of the drones and throwing the sledgehammer through the giant screen, basically saying that IBM was the Orwellian monolith and they were going to set the world free with the Apple II.
Amen. Coming to break, we'll be right back with Ladar Levison. Stay tuned, guys.
This is the Logos Radio Network.
For the longest time, for the longest, if you said that Bitcoin was my life, I would tell you,
show enough, show you right.
What else can I do? I'm so inspired by you, and I'm just holding for the longest time. Once I knew my stocks and bonds were gone, I knew Satoshi Nakamoto was the one to come and save me. Encrypted money memory, and I'm just holding for the longest time. Hold for the longest time. Hold for the longest.
All right, guys, welcome back to the Crypto Show. We are talking with Ladar Levison of LavaBit and Darkmail. And we'll get to talking about Darkmail shortly. It did come up just a few minutes ago. And as Ladar said, he was sort of a precedent setter himself in the email service security space. And he is years ahead of what's out there, which is really exciting. And we'll talk about that progress, coming up. But let's keep talking about the current stuff and flesh it out a little bit more. One thing Ladar mentioned over break, a sort of nuance that was lost on me, but was very.
You're teasing the listeners. This is the second time you've talked about the awesome stuff I say when nobody's listening.
Everyone's listening. We have like a handful of listeners.
Yeah, somewhere in where's that? Utah?
I think Utah.
Blood relatives do not count.
Oh well,
no, we're talking about the NSA, that big NSA building.
You're talking about the Utah data center.
Yeah.
I was talking about the Mormons. Mormons love us. Well, anyway, you said something very insightful. I think makes total sense. Is that as we were trying to tease out, the FBI was not necessarily inclined to actually carry the case through, or any of these cases.
They were certainly inclined to carry this case forward because, like I said earlier, the facts in the case, the optics of the case, the emotions in the case were certainly very favorable to them.
Well, I'm into its conclusion. Go ahead.
Yeah, the only thing working against them is that this particular case was in the Ninth Circuit, which includes the state of California and, of course, Silicon Valley. And that particular circuit is not necessarily does not necessarily have a strong tradition of being pro-government. Now, the particular magistrate who was going to hear the case first was a former prosecutor. So that was certainly favorable. But it would have been quite likely that if the magistrate had ruled in the government's favor, Apple would have been able to get the decision overturned at a higher level. But like I said earlier, they backed down before any punches were really thrown.
Right. But what I was leading to, too, is the insight you gave us over the break, which is that they backed down, perhaps in part because it wasn't in their best interest to make it proceed through the courts, but instead make it a high-profile case and back down and use as an excuse to get Congress to legislate, in order to maybe get what they want that way. Is that basically
just
what you're saying?
They do with like a SOPA and PIPA and all that. They just keep renaming it and bringing it back until they can get it through. And they'll probably do the same with this. Until they not only get a back door, but they'll open the whole back of the house.
Yeah.
The thing about our elected leaders is they never like to take anything away, because when they take something away, they're likely to anger somebody. But yet at the same time, the goal of every politician is to have a freeway named after them. So they like to introduce new things. It's like continuing to throw shoes in the closet. And if you run out of room, you just tear down a wall and build a bigger closet. But nobody likes to throw away the shoes because, like I said, they'll piss somebody off. So you kind of hinted at what I said over break. I was hoping you'd set me up better. We got to work on that. Go to some dance classes or something. But what I was implying is that the government was certainly and appeared to be and likely would have followed this case all the way through, at least to the circuit level. I don't know if they would have taken it up to the Supreme Court level. But when they saw the wind of political opinion and their legal argument getting demolished, it was certainly could be viewed as a somewhat shrewd decision to back out before they took the loss. And what I was saying is, from the FBI's perspective, it could be viewed as a triple win. They didn't get the precedent, but they got access to the phone. They have a situation now where they can go back to Congress and they can prove that Silicon Valley is not going to provide this type of what I call extraordinary assistance, and use that as sort of a benchmark example of why Congress needs to act, because Congress has considered legislation several times that would have, for example, set up penalties, mandated that Apple provide this specific type of assistance, and set up penalties, both financial and criminal, for refusing to cooperate. Like I said, they can claim that they're still undefeated, right? Going into the next case, there isn't a situation here where the next victim can point to this case and say, Your Honor, you should deny the government's motion because the court out in California has done so previously. So for them, it's kind of a triple win.
That's pretty diabolical. I mean, I have to give them credit for being conniving and clever.
Let's see you try that.
We are talking about the FBI. I would expect nothing less from them.
Well, and speaking of which, another thing that you brought up over break that I thought was interesting, well, Danny kind of brought it up first, was Obama, when he was here in Austin, gave a speech and alluded to various sort of security and encryption matters. And you characterized his speech as being relatively ambivalent concerning what he was pushing legally, if only implicitly in that speech, or at least the degree to which the White House might be involved in pushing any agenda. But on top, in addition to that, we also talked about how the head of the FBI is sort of understood to be the de facto head of the Justice Department, even above the secretary.
That wasn't what I said. What I said is that many people in Washington consider the director of the FBI to be more important than the Attorney General, even though the Attorney General is at the head of the Department of Justice, and technically the FBI is inside the Department of Justice.
Right. Well, sorry, I probably misspoke a little bit, but that's basically what I was getting at. Thank you for clarifying. But so I guess my point is, are we really to take Obama's ambivalence seriously when clearly the FBI and the FBI director are going one way? And that, to me, signals that the White House itself is totally on board with that.
Well, full disclosure, the spokesperson for the White House came out when this story broke and said the Department of Justice consulted with the White House, but the White House didn't provide any guidance, that President Obama wanted the decision on cases like this to be made within the Department of Justice. So he has that hands-off approach. He clearly agrees with their decision, but if it blows up, he's got plausible deniability. You could say a lot about Obama, but he is certainly a very shrewd politician. And I've said this before, but I believe his background as a civil rights attorney has made him particularly adept at painting gross violations of our civil liberties in the best possible light, such that the masses tend to give him the benefit of the doubt when he uses words like adequate protections, checks and balances in the spirit of the Constitution. In other words, he can completely destroy the freedoms in this country and get the bulk of the populace to say thank you for having the privilege of being his victims.
Please have some more, yeah.
It's not quite that diabolical, but like I said, he's got the right verbiage.
Right, well, you never know.
These things to the public.
We'll be right back from break, guys.
Just get more.
Attention air travelers. Before you book your next flight, be sure you don't get stuck in the worst seat on the plane. I'll give you a hint. It's near the back. I'm Dr. Catherine Albrecht, back with a tip from seasoned travelers after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
If you've flown lately, you know the skies can be far from friendly. There's baggage fees, jammed overhead bins, and shrinking legroom. And of course, choosing the right seat is always a challenge. But a survey of 1,000 flyers by Skyscanner, a flight comparison website, finds one seat is the absolute worst, 31E. It's a middle seat in the back, near the toilets. Of course, where there's a loser, there must be a winner, and that award goes to seat 6A. Why? Seasoned air travelers know the first few rows get to deplane first. Plus, 6A comes with a very nice window. Happy flying! I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
You're listening to the Logos Radio Network at logosradionetwork.com.
I've been walking a tightrope between fact and fiction, been wrestling with demons in small bottle prisons, been talking to sinners who claim to be Christian, but shouting at leaders who claim to be listening, and the pendulum swings from the left to the right. Momentum increases.
Welcome back, guys, to the Fat Married Couple and Ladar Levison. Never mind, inside joke. I forget the listeners aren't privy to those. But we are in our second to last segment with Ladar, and I do want to talk to him about some of the stuff he's up to here in just a moment. But
we should conclude. We teased him before the break. We should actually try to paraphrase what Obama said at South by Southwest, which is something along the lines of the technical community should come up with a solution that allows law enforcement to get access to the data with a proper warrant. Otherwise, they risk something horrible happening and Congress rushing through some ill-considered piece of legislating, dictating a particular solution which benefits nobody.
Was that a paraphrase or exact? Or
that's a pretty accurate paraphrase.
Well, what I got from it is that he wanted my Bitcoin wallet from my Swiss bank account in my pocket.
It all stems from the fact, and I learned this the hard way back in 2013, that the FBI and in turn the Department of Justice attorneys feel, quote, entitled, end quote, to all of our plain text data. And they don't necessarily care what sort of collateral damage might happen to a disconnected third party in pursuing access to that encrypted information. From their perspective, it's our fault for designing these systems in such a way that they can't get access to the data with a court order. And literally, the first time I appeared in court, you can go back and look at the transcript, the prosecutor actually used the word entitled. He said, Your Honor, we are entitled to this metadata that we cannot collect without Lavabit's TLS key.
Well, taking the entitlement mentality to a whole new level, that's crazy.
And I almost said something, but at the time, I didn't actually know the law well enough to say, Your Honor, he's off his rocker. And I really wish I had. There's part of me that kind of wants to start that whole process over. And, since I'm so close to relaunching Lavabit, there's a good chance it might actually happen. There's also a very good chance that I won't be the test case the next time this issue comes around. Just like there's a pretty good chance Apple won't be the test case the next time this comes around.
What do you mean by that?
What I mean is by my attorney's own estimate, Apple spent over $1 million litigating the San Bernardino case all by itself. They have some of the best lawyers in the country representing them in this fight. Ted Olson, former Solicitor General, he was the man that won the Bush v. Gore Supreme Court case. Basically, you could call him a kingmaker, right? He was set to argue that March 22nd hearing. His co-counsel is Mark Zwillinger, an attorney that I came in contact with back in 2013. And a very sharp litigator when it comes to surveillance issues and service providers. He's litigated several issues, both in district court and inside the Foreign Intelligence Surveillance Court. Most notably, he's associated with the PRISM decision involving Yahoo, a case which he lost, but which was declassified back in 2015. Now, I've been told I can't speak of this firsthand, but I believe Congress recently passed legislation overhauling some of the procedures used by the FISC, and that there are now 5 external lawyers that are sort of picked as advocates of the people and to argue against the government inside the FISC. And Mark Silver is one of those 5.
Sorry, the government handpicked those 5 to argue against the government, or what was the?
I don't. That's like I said. I didn't hear about that particular legislation being passed, so I don't know the process for picking those 5.
It sounds fishy.
Tell me that he was one of the 5.
I see. I mean, yeah, I don't know the details, and that makes all the difference. But that just sounds fishy.
I remember when it was proposed. I just didn't hear about when it was actually passed, and that could be because it was part of, an appropriations bill. Congress loves to tack things onto those, especially when it involves little old ladies, because nobody wants to vote against little old ladies.
Of course not.
Even if it means, deputizing an army of stormtroopers and deploying them to American cities.
I know, that's the thing. It's like, you don't want to deny.
Exaggerating, not as you think.
I mean, it's exaggerating maybe right now, but wait 5 years. But yeah, they love to. You don't want to deprive Granny of her Social Security check, do you? And then they, they pass a bill for martial law or God knows what. That is one of their favorite tactics, to be sure. Well, actually, real quick, I'm curious. I mean, you were saying you can't speak firsthand, and I don't know if you were referring specifically to PRISM, but can you?
I can't speak firsthand about the legislation that overhauled the procedures inside the FISC. And created these 5 new positions. It might have been part of the USA Freedom Act. I don't quite recall, but I heard that just in the last couple of weeks, that he was one of the 5 attorneys picked for that job.
I see. USA Freedom.
And he is certainly a very well-qualified lawyer. And, these 2 guys were flown in from Washington, D.C., and of course they had to pair up with counsel that was a member of the court in Southern California. But it would be fair to say that Apple brought in its double-barrel big guns.
Yeah, the big guns.
And, there is a reason that the Apple reply brief was written so well. And like I said, I don't necessarily think the Department of Justice is afraid of these 2 particular gentlemen because, you have to remember the Department of Justice is the largest law firm on this planet. And for hotshot young lawyers coming out of law school, the Federal Department of Justice is one of the ideal first jobs, particularly for people who are inclined to go into public service. You either want to end up as a clerk, in the Supreme Court or as a prosecutor for the Department of Justice. For going into public service, a state prosecutor would be second, city prosecutor third, litigating traffic tickets might be fourth, and public defender fifth.
Public defender, yeah, definitely at the bottom of that.
And the thing is, the public defender's office, to be fair, does get a number of very dedicated and many times very skilled attorneys, but they are certainly understaffed, have fewer resources.
Right.
The point I'm trying to make is that if you go into a fight with the Department of Justice, you are always starting at a disadvantage.
Oh yeah, and as big as the pockets and influence of Apple are, and like you said, their legal roster there is utterly impressive, and of course, even to some extent crisscrossed, at least formerly, with the Department of Justice or other government departments. But yeah, I love the way you put it. The Department of Justice is the single largest law firm in the country. So yeah, if you're picking a fight with them, the planet, the planet.
They have an annual budget of roughly $10 billion. The Department of Justice as a whole, at least back in 2013, and it's gone up significantly since then, had a budget of $27.1 billion, and approximately $10 billion of that was dedicated to what they call legal activities. The Department of Justice in 2012 employed over 113,000 people.
Wow. That's a lot of people.
When people talk about the fact that we have too many lawyers in this country, that's kind of what they need.
That is a great little soundbite there. We should go through and take those out. I love that.
Raid!
I know, right? No, we're coming to break. The last segment, I want to talk to Ladar finally about dark mail, what's going on with that. But it's so true. They got the big guns over there. And what is Apple's market cap?
Well, they're the second largest company in the country. I know we're running out of time, but I would just say that I think the next time the government decides to litigate this, they're going to pick a much smaller company.
Easy.
All right, guys, welcome back to the final segment of the Crypto Show. We're talking with Ladar Levison about the FBI Apple case, about his own case, about a lot of other things, all related. We're going to get into Dark Mail 2 in this final segment, but Ladar, you brought up a good point over break. We got a little too bewildered amidst the legal aspects of all this. Let's quickly delve into the technological aspect of this. So they did break into the phone, is what you're saying.
Well, no, I was just saying that I think the government's going to keep the next one in the closet, litigate it in secret and get their precedent and announce it as a fait accompli.
Right.
But yeah, no, technologically, unless you're an engineer, it's kind of hard to understand how the government could have broken into the phone. And very early on in the show, you actually said they were paying to break in via software. And that is actually likely to be untrue. One of the attack vectors would certainly have been to wait for a vulnerability to be discovered in iOS or one of the applications that was already installed on that phone and use that to break into the phone. I'll give you an example. There was a story that came out a couple of years ago. Apparently, people who had the Angry Birds app on their phone, it was periodically starting up and going out to the Angry Birds servers and uploading personal information off of people's phones, and then, of course, downloading stuff from the Angry Birds servers, and wasn't doing it using any form of encryption or authentication. So they could have, found a situation like that, waited for that process to kick off, and use it to inject something onto the phone. Like I said, find a vulnerability in the operating system that could be exploited while the phone was locked, or they could have found a company that was cooperating and use that as a method of sort of getting their toe in the door and going from there. All of those methods are likely very hard, require patience, although it is widely speculated, depending upon who you talk to, that there's a good chance the NSA might know a trick or two that hasn't been disclosed to the community that might allow that type of software attack. The more likely attack vectors are all based on hardware, and I'm going to do my best to describe them. I am certainly not a chip designer or an electrical engineer, and of course I told you earlier, the only iPhone I have has been powered off for a couple of years, and it's only around because I need it for iOS development. I am certainly not an expert on their inner workings, but the simplest method that has been theorized is that several researchers have speculated that you could solder a couple of connections and flip a couple of circuits on the iPhone board once you disassembled the phone, that would basically make the device read-only, so that if you inputted the password incorrectly 10 times, it wouldn't have the ability to blow itself away. And, if that theory was in fact correct, that's the type of thing somebody could do with a soldering iron at an extra half hour to an hour. Of course, then they'd have to sit around and type in, all the different combinations, but that's what rookies are for. And paralegals, So,
yeah, exactly.
The method that I particularly favored as being one of the better options would be to decap, what's called decap the chip, which is basically take the hard ceramic wafer off of it inside of a clean room and expose the internal electronic circuits, which could be examined under something like an electron microscope, and then presumably somebody with enough patience, skills, knowledge, and resources could use that insight into the inner workings of the chip to possibly discover that secret piece of information that's unique to that particular iPhone. And then, of course, once they have that, they can disconnect the storage module from the device and brute force it using a separate standalone reader rig.
Wow. So they would get down to like the logic gate electron level to the very basic level of the microchip to figure out how to crack into it.
Exactly.
That's crazy.
That's the type of thing that somebody with lots of resources could do. There's a variation of that. There's a device that's used during chip development that's very, very expensive. But I don't remember off the top of my head exactly how it works. But based on what I read very recently, if it's correct, uses an ion-based laser that allows it to penetrate the ceramic coating and manipulate the inner workings of a chip. And like I said, it's often used during integrated circuit development when a company like Intel or AMD gets a prototype back from the fabrication facility, discovers an error. They will use these machines to test a potential fix. The downside to this particular approach is that typically, if you use this approach, the chip will only continue to function for approximately 20 to 30 minutes after you make that kind of a modification. But presumably, if they had access to the specifications, the diagrams for the inner workings of this chip, they could modify it to spit out its dirty, dark secrets.
Wow. So they could just rewrite the chip with this laser. And if they did it,
and tell it that it should spill all the beans.
Wow.
The final method, which was actually demonstrated as a proof of concept in a video very recently by a security researcher that I know, Jonathan Zdarsky. I hope I pronounced his last name right. If not, I apologize. But he, at least for this particular iPhone with this particular version of iOS, apparently the number of attempts is stored in a file on the SSD. In other words, it doesn't record that number outside of the storage chip, for example, in the processor. So what you could do is, with enough skill, and this is admittedly somewhat difficult, but there are people who are good at this because they do it all the time, desolder the SSD chip from the integrated circuit, make a duplicate copy of it, put the chip back in. Presumably you would add a socket, which from that point forward would allow you to remove the chip quite easily, make 5 attempts, reboot the phone, and then reset any of the blocks that were manipulated in your previous attempt. Try 5 more, reboot, process continues until you've discovered the particular PIN code. It would be a time-consuming and delicate procedure, but with some specialized hardware designed for the purpose, could be done in a very reasonable amount of time because you could automate the entire process. Where, the phone is basically hooked up to a simulated SSD, so it can be reset quite easily. And of course, once the phone's been taken apart, that device could also cut the power whenever it needed to trigger a reset. And of course, once you have the device open, you can also robotically or programmatically stimulate the correct circuits for the input of the digits.
God,
again, this would take very specialized knowledge and development of very specialized hardware, but that is certainly a method that was proven, at least in this proof of concept, to be viable for this particular model.
Right, but when you combine it with the heavy resources of the federal government, it's not implausible at all that they might attempt that. That's interesting. That's some fascinating stuff. I'm glad we finally got to that because that is just crazy cool stuff to think that they can do that. Well, we only have like about 2.5 minutes left. Ladar, I hate to end this show without getting to dark mail. Tell us about
what I've been working on. I've been doing a lot of political activism, speaking at conferences, talking to guys like you and explaining all of the issues, because I view that as being very important. But I also didn't place all my eggs in a single basket 3 years ago. I pursued the political avenue where I haven't gotten very far. In fact, I recently nominated about 15 individuals for a potential congressional privacy commission that I'm sure is being ignored. That's on Facebook if anybody's interested.
What's the Facebook group?
For relief from the court. So the second avenue was, of course, legal. But anything created by man can be undone by man. So my ultimate solution was to focus on technology. And the epitome of that is the Dark Mail Project, which is essentially can be viewed as a framework that allows the user to take back control over the privacy of their emails by creating a framework that allows them to pick from 3 predefined levels based on their perceived threats how the encryption process is handled. And, it would basically solve a lot of the security problems with email. And, of course, I've been working on that for about 2 years now, and it's on the verge. It's on the cusp.
Well, 45 seconds left. Take us out. But
prom night. But right now, I'm in talks with some venture capital firms to raise some money, hopefully, and relaunch LavaBit. But anybody who wants to help out with that project, go to darkmail.info, and there's a donation link, there's a specifications link, there's a link to the GitHub repos, and, of course, donate to keep the good work going, including, all of these various legal activities, which are certainly far too expensive.
Absolutely. And, of course, you can follow Ladar at King Ladar on Twitter.
And Facebook.
And Facebook as well. Ladar Levison, you're awesome. Thank you so much.
You're welcome.
We'll see you guys next time.